Senator Hanson.
Look, I have concerns about this bill, and I think on behalf of the Australian people I'm going to make my concerns known. It may sound good, and we've got Family Law Court 1, we've got 2, and that was because the two courts were separated. We had the Family Law Court, which dealt with more important issues, international law, property settlements, and those cases that were not settled in the lower courts were brought to the upper court. The Family Court 2 basically is a lot of judges who deal with family law, plus also migration issues, and that's the Federal Circuit Court. The two courts were merged under the coalition government, which I fully supported, and I think it was a good move. My concerns about this is that the Australian people, to give these judges immunity on their decisions, that concerns me. How are they held to account? I was told they can actually appeal. People can appeal. Usually after they've gone through the family law courts, they're drained. They're actually, a lot of people can't take it anymore, fed up with the court system. They actually are desperate. They've probably sold their home. They've got nowhere to live. And their finances are rock bottom. They're at rock bottom themselves. And to see that a decision that's handed down by a judge who cannot then be held to account for their decision. A lot of these parents that are brought before the Family Law Court, and I've dealt with them over the years, and they're really so distraught because most of the time a lot of these parents don't even get to see their children. They've got no time with the children, and that's the decision of the courts. Why aren't they held to account? Well, you can say they can appeal, but like I said, they can't afford to. So who is going to hold them to account? These judges must be held to account, the same as what I believe, that bureaucrats should be held to account, politicians should be held to account on the decisions that are made that impact on the Australian people. And I think that just saying, oh no, let's treat them all the same, let's give them immunity so that the people can't have recourse to actually say, listen, what sentence you gave me, they say, oh well, you can actually appeal, you can write, and you say, well, the judge didn't read these papers or the judge didn't made the wrong decision. How are they going to prove that? How are you actually going to say to a judge, well, you didn't read it. It's his word against yours, that he read it. That's the decision he's made. How is a person going to hold a judge to an account if you appeal their sentence? It's not going to happen. We all know that. A lot of these judges are protected species. Same as bureaucrats, same as politicians. And I just think there has to be some accountability for the people of this nation. And when we see what happens to a lot of these families, the Labor government just passed, their family law bill, and which I've opposed as well. And I just kept saying is, where's the accountability there? And you talk about the rights of the child, and yet you forget to say about the rights of the parents to actually have that right to see their children. But it's like, oh well, it's just the rights of the child. Couldn't even answer the questions. No one can answer the questions in this place. You just go back the same old hearsay, the rights of the child. Well, where's the rights of the Australian people to have that protection so that they can? And what I'm hearing also is that, some people, parents are actually fed up with the decisions, denied rights to see their children for years on end for no real reason whatsoever. And they've been blocked, or they can't afford to take it back to court to get some justice. And they are absolutely devastated. So where is their rights? You deny them their rights, but you actually want to protect the judges. You want to give them immunity from what? Immunity from the people being able to hold them to account. I don't get it. I don't understand. And this has been supported by both sides of Parliament. I don't know how the Greens or the crossbench feel about this, but I just don't feel it's right. People should have the opportunity to hold these judges to account. And then I've heard also, well, the judges will be in fear of handing down their decisions because they're not going to be there's not going to be immunity. So when I hear of a class action against some of these judges and the decisions that are being made, that they're going to actually have a class action against these judges, if you actually bring this in, they're not going to be able to have a class action against these judges and the decisions that they made. So you're shutting the Australian people down, an opportunity to hold them accountable for the decisions that they have made. And this affects so many families, so many people out there. Sorry, I'd like this to actually go to committee. I would like to be able to ask the Minister some questions with regards to this. So I won't be supporting this to actually be shut down. I'd like it to go to committee so that I can ask some further questions of the Minister with regards to this bill.
Thank you, Senator Hanson. Minister.
Thanks, Acting Deputy President. This bill would make an important amendment to ensure judicial independence and support access to justice in our largest and busiest federal court, the Federal Circuit and Family Court of Australia Division 2. The bill would achieve this by clarifying the scope of judicial immunity for judges of this court. The common law doctrine of judicial immunity serves a critical purpose, and it is important that its scope and operation are clear. Where there is the potential for uncertainty or inconsistency in its application, it is appropriate for legislation to provide that clarity. It is essential for our justice system that judges are free to decide matters before them in accordance with their assessment of the facts and their understanding of the law without the threat of being sued. This amendment would ensure judicial independence, support each person coming before the court to receive an impartial and fair decision, and minimise the risk of vexatious litigation aimed inappropriately at judges from those who are dissatisfied with the outcomes of their decisions. The bill would not mean judges are unaccountable. The bill would not affect a person's right to challenge judicial decisions through the appeal process, nor the ability for Parliament to consider the removal of a judge from office under our Constitution on the ground of proved misbehaviour or incapacity. The prospective nature of the bill would not impact on matters currently before the courts or any causes of action that may have already accrued. The amendments the bill would make are simple. The bill would provide that judges of Division 2 of the Federal Circuit and Family Court have the same immunity as judges of Division 1 of the Federal Circuit and Family Court. By extending the more settled and broader common law immunity that applies to a judge of a Federal Superior Court to judges of Division 2 of the Federal Circuit and Family Court, the bill would achieve the aim of providing clarity but would allow room for the common law doctrine to be refined over time. The bill would also make consequential amendments to 4 provisions across the Federal Circuit and Family Court of Australia Act 2021 and the Family Law Act 1975. These consequential changes would ensure that, following the change to Division 2 judges' immunity, there is no confusion about what protections apply to certain individuals who are exercising quasi-judicial functions. Judicial immunity ensures that judges are able to make independent decisions free from any external influence outside of the law itself. In this way, judicial immunity is about protecting everyone who comes to a court. It does not mean judges are unaccountable, and this amendment is not about protecting the personal interests of judges. We are all entitled to a fair and public hearing by an impartial court, and clarity about the scope of judicial immunity is an important prerequisite to achieving this. This bill would provide necessary clarity about judicial immunity and, in turn, assure the timely and effective administration of justice.
Thank you. The question is that the bills now be read a second time. Those of that opinion say aye. No. I think the ayes have it. The ayes have it. No amendments have been circulated. Does any senator call the clerk?
A bill for an act to amend the law relating to federal courts and for related purposes.
No amendments have been circulated. Does any senator require a committee stage? If not, Senator Hanson?
I would like a committee stage.
You'd like to go into committee?
Yep.
Is it the wish of the committee that the bill be taken as a whole? There being no objection, it is so ordered. The question is that the bill stand as printed. Senator Hanson?
Yes. Minister, in the bill, can you tell me who is protected under this immunity, please?
Minister.
Thanks, Chair. Thanks, Senator Hanson. The measure would provide that a judge of Division 2 of the Federal Circuit and Family Court of Australia has the same immunity as a judge of Division 1 of the Federal Court and Family Court of Australia.
Senator Hanson.
Would you please explain what the immunity is given to the judges of the Family Court 1?
Minister.
Thanks, Chair. Sorry, I didn't quite hear the end point of that, Senator Hanson.
Senator Hanson.
What the immunity is given to the Family Court judges of Court 1?
Minister.
Thanks, Chair. Thanks, Senator Hanson. Case law suggests that judicial immunity applies to judges of inferior courts more narrowly than it does to their superior court counterparts. This has created uncertainty for litigants and for judges of the Family Court the Federal Circuit and Family Court Division 2. The bill would minimise the risk of vexatious litigation aimed inappropriately at Division 2 judges from those who are dissatisfied with the outcomes of their decisions. This bill would also support the underlying aim of the doctrine of judicial immunity by enabling Division 2 judges to discharge their judicial functions impartially, fearlessly and in accordance with their assessment of the facts and their understanding of the law without undue influence or the threat of being sued.
Senator Hanson.
If a person of courts was not happy with it and you say you're going to allow immunity to that judge, what course of action then does the person have?
Minister. Minister.
Thanks, Chair. Thanks, Senator Hanson. The appeal process.
Senator Hanson.
Through the appeal process, we talk about the decision that judges have brought down. As I said in my remarks, that a lot of these people are at their wit's end and they don't have any more money to throw at solicitors to actually put their case forward. What other process could there possibly be for them if they feel that they've already spent years waiting for decisions to be held, for the courts to make the decision, based on a lot of the parents that I've spoken to also have said they feel biased in the courts because of who they are, lies have been told. Look, my concern is a lot of parents that I've spoken to, they go to the courts, they give their evidence, and even in the court system there is perjury. Yet they don't feel that their counterpart, who is actually going against them in the case, their ex-partner or their wife or whoever, ex-wife or whatever, lies are being told, and I've got to say from men as well, lies that are told in the court, that there's no accountability in the court system, there's no accountability for perjury, that the judges don't pull them up for perjury. Why are we then making them giving the judges immunity when the judges themselves will not adhere to the rules of the court and perjury is not allowed? Minister.
Thanks, Chair. Thanks, Senator Hanson. The Federal Court of Australia Act 1976 and the FCFCOA Act empower the heads of jurisdiction to consider, investigate and handle complaints about the Federal Court and FCFCOA judges as well.
Senator Roberts.
What does that mean?
Minister.
I've answered the question.
Senator Roberts.
Could you please translate that into everyday language?
Minister.
So,
Hang on. Senator Hanson, were you on your feet? I'll come to you.
No, Senator Roberts standing.
Senator Hanson.
Senator Roberts asked a very direct question of the minister with regards to an explanation of his statement that he's just made. Now, I think in light of that, if you've made the statement, Minister, please, in layman's terms, so that even I can understand it, if you would please, I would like to understand what you've just said in this chamber. Can you please explain?
Minister.
Thanks, Chair. Thanks, Senator Hanson. So, as I said, the Federal Court of Australia Act 1976 and the FCOA Act empower the heads of jurisdiction to consider, investigate and handle complaints about Federal Court and FCOA judges. So that's the additional process. Obviously, they've got the appeals process that someone would be entitled to pursue legally as well. You're asking about what additional measures there were. That was the additional measure.
Senator Hanson.
Can you tell me then, if someone feels that they've been wrongly treated in the court system, that someone has perjured them as a witness on the stand, they perjured themselves, what course of action do they have if the judge will not take that into consideration? And then how does that respondent, how do they deal with it? If they can't hold the judge to account for his decisions that are made, you're giving them complete immunity, basically, if they make the wrong decisions, but they haven't run their court correctly and pulled up anyone for perjury.
Minister.
Thanks, Chair. Thanks, Senator Hanson. It's the same answer as the one before, Senator Hanson.
Senator Roberts.
Minister, how many times have the additional measures been used?
Minister.
I don't know, Senator Roberts. I'm happy to see if we can take advice on that and come back to you.
Senator Roberts.
My concern is that the legal system is a closed system. I can give you an example, but it belaboured the point. Someone who's been trying to get justice for 9 years. He has been thwarted by the plaintiff, who is a very large corporation, thwarted by the judges, thwarted by the lawyers representing him and the large corporation. This is a closed system, a closed club. How do people know, how can they be reassured that this will not lead to less openness?
Minister.
Thanks, Chair. Thanks, Senator Roberts. The courts act independently. Senator Roberts.
Senator Hanson.
Minister, what we have a big problem with in our society is the time that judges take in handing down the decisions. And it can actually be as long as 1 year, 2 years, even longer before they hand down the decisions. By you actually giving them immunity, and that means someone can't sue them for it, where does it leave these people who are so frustrated with these judges that have taken so long to hand down the decisions? What recourse do they have? What can these people do waiting for these long sentences?
Minister.
Thanks, Chair. Thanks, Senator Hanson. The standard complaint process would be enable them to complain to the Chief Justice of that court.
Senator Hanson.
Yes, look, I won't keep this going. I have my grave concerns about this bill. I think you're actually giving the immunity to judges where I think they need to be made accountable. I think I've made my comments quite strong on that. You know, it's my concerns for the general public that they don't have a recourse anywhere. You're shutting the gate on them. You're not giving them, you know, to make these judges accountable to the public, and it's a real shame. I think that you can keep writing, it's closed shop, and I hear that constantly all the time. People are distraught They don't know where to go. They turn to politicians. I tell them all the time, it's a separation of powers. We can't get involved in this, and that they have to keep fighting on. And like I said, when I hear people on the end of a telephone call, or I get pulled up in the shopping centre, or wherever I go, people are telling me their stories of how they're being separated from their families, from their children, how distraught they are. They're on, the bones of their backside. They've got no more left in them. They've got no money. They've lost their houses. And this just goes on and on and on. And yet you're in this chamber and you're telling me you're going to give the judges immunity. Where's the immunity for the public? You passed further legislation just last week, the family law courts, where you're going to do more damage to the families out there. And what's happened in, child support, who knows what you're going to do with that one once you bring that bill before this parliament. And I just don't feel that the people of Australia are being listened to. You don't have the answers. You haven't got the answers here. You're just protecting, like I said, these people, the judges, who are in fear. They don't want to be sued. What we've had, how many judges? Is it one judge that's been sued? So therefore we must actually make sure that it doesn't happen to another judge. Yet how many thousands and thousands of people, hundreds of thousands of people have been affected by the court system and what they've done to the people of Australia. I don't believe this. You're so quick to move to protect the judges from being sued. But you don't basically worry about the Australian people to get it right in your family bills, law acts that are being passed in this place. It's a real shame. And I'm sure that the next one you pull up with the child support, you'll be doing the same, slapping people in the face out there and about the children. But anyway, I've made my point here, and I'm sure that the Coalition and Labor, you'll cuddle up beside each other in this bill again and you'll pass it, and with no real oversight in thinking what the public have to deal with now. Anyway, One Nation will be opposing this.
Minister.
Thanks, Chair. Thanks, Senator Hanson. We don't see judicial immunity as for the personal benefit of judges. We see it as something that protects everyone who comes to court by ensuring judges can make independent decisions free from external influence. So that's why we think this is important.
Senator Roberts.
So, Minister, I acknowledge the fact that there are two sides to this. What Senator Hanson and I keep hearing is that essentially there are 2 points. There's a hell of a lot of regulation, and that regulation, wherever it's immense, favours the big boys, the big corporations, the wealthy. The legal system is becoming less and less accessible to everyday Australians, along with housing, becoming less and less accessible. Is the government doing anything to make it more accessible?
Minister.
Yeah, thanks, Senator Roberts. As I said, what this is about is actually about judicial immunity. It protects everyone who comes to court by ensuring judges can make independent decisions free from external influence. So we think that benefits everyone who comes before the court in this instance.